welcome everybody to a new issue of Seasons Ebb and Flow. I am very excited again today to be interviewing Thomas Marks. He's been with us before to talk about collaborative divorce. And today we're going to ask him a few questions about just the nuts and bolts process steps, because sometimes people don't get that much information from their lawyers, or they're waiting on information and they just want to know kind of like, what are some of the steps? What does it mean once one thing has happened? So I'm first just going to let Thomas tell us a little bit about his practice and his background.
Okay, thank you, Lee. I appreciate it. Always enjoy being on your show, your YouTube channel. So let's see, I've been practicing coming on 39 years, believe it or not. I started my firm, March 1st next year will be 33 years ago that I started the Marks Law Firm. We are located at 733 North Magnolia Avenue, Orlando, downtown Orlando. I do exclusively family law. Have 3 associates that all do family law, and so that's what we specialize in. Yeah, I enjoy the practice. Believe it or not, I know a lot of family law attorneys may not enjoy it, but we're very selective on the clients that we take, and so we make sure that we represent good people because we want to do good work for good people. And so, yeah, I enjoy it. I do a lot of collaborative, but I also do litigation. So I know how to do both. So I think that's what we're going to talk about today, is the litigation aspect of it.
Yes. All right. Thank you. Well, yeah, I think it's interesting. It must be nice to be able to be selective and choose clients that you think are going to participate and be respectful to you, their exes. The process makes a big difference.
It really does in how you practice, because, you know, good clients refer good people. They give Google reviews. Bad clients refer bad clients and don't give Google reviews. So, yeah, we've been very successful in representing good clients, and it's made the practice that so much better.
Yeah, wonderful. All right, so to get right into some of the questions, when one person files for divorce, or let's say one person hires an attorney and that attorney submits the documentation to start the process, what are kind of the things that happen once that attorney has filed for divorce?
Okay, so let's assume that the client has been served with the petition for dissolution of marriage. That's what's filed by the other spouse in the court. And so that starts the time clock ticking. The recipient of the pleading, the petition, has 20 days to respond in writing to the clerk of the court. If they don't file what we call a responsive pleading, which could be an answer, it could be a motion to dismiss, could be a number of things. But if they don't file something with the clerk within the 20 days, then the clerk can default them. The other attorney can file a motion for default with the clerk, and a default's entered, and it's going to be a big problem for the client. So they have to make sure they get something filed with the clerk within 20 days. Even if they just get anything filed, then the clerk's not going to be able to file or enter a default. And then the other attorney would have to file a motion to get a hearing with the judge and notify the party that was served. So the party that was served would at least get an opportunity to retain an attorney to defend that or to file their answer before the hearing.
Okay, so I guess if that person who was served doesn't have an attorney yet, they can go to the courthouse and have them maybe help them respond if they don't have time to hire an attorney. I mean, 20 days is a good amount of time.
Yeah, the clerks, unless the recipient of the petition, unless they're like not able to afford an attorney and they apply for indigency, sorry, that's a hard word for me,
Yeah.
status, that they can't afford an attorney. I don't know if the clerk is really going to help them very much.
Yeah.
It's really better for them to at least have a consult with an attorney so
Mm.
the attorney can advise them and say that you need to file an answer or this is not a proper pleading, so file a motion to dismiss or something like that. But get something filed within the 20 days.
Okay. And is the 20 days specific to Florida? Like, does each state have a different timeline?
So I'm licensed to practice in Florida. I'm not permitted to give legal advice regarding other states. So I
Okay.
can only talk about
Speak to
Florida.
Florida.
Yeah, I'm
Okay,
sorry.
no, that's fine. That's helpful. Um, Now, when I got served and it was like the traditional, like, knock on your door, here's your papers, and I
Mhm.
didn't even know that he'd hired an attorney. So it's kind of like very shocking. And we had planned to do an amicable divorce. So that wasn't kind of what I was anticipating. Uh, but since then, I learned that it's possible to not have someone be like served like that, where like you can have a letter or they notify. What are the options so that you don't have to have that very kind of antagonistic start?
Yeah, and I really so if a client comes in to see me and they're considering divorce or they think their spouse is, I can call the other attorney and tell them we'll accept service for the client. So then there's no need for a process server to hunt down the client or embarrass them at work or in the community or at home
Yeah.
because the attorney can accept the service for the client. A letter from the other attorney to the client is not sufficient to
Okay.
start the process. It either has to be a process server handing the client or leaving with somebody in the house or the attorney accepting service.
Okay. Okay. That's good to know.
Hmm.
Um, I mean, this might be kind of out of your scope, but like, let's say a couple wants to try to hire a mediator first and see if they can, how far even they can get through the process. Does the mediator then do the filing for both parties and kind of manage that, or do they have to figure that out on their own?
Yeah, okay, so that's a good question, actually. That's an option that I'll discuss with clients when they come in that they could go. Let's say the wife comes in to see me and they say it's going to be amicable and they want to do it inexpensively. Then the husband and wife could go to the mediator and the mediator could help them reach an agreement. Now, mediators are not allowed to give legal advice, even if they're an attorney, because of their rules. So the mediator is just helping the two parties. So what I might tell my potential client is, well, you could go to a mediator, work out the details of the settlement agreement, either a parenting plan or a marital settlement agreement or both.
Right.
Um, and then you could put in the agreement subject to my attorney's approval within 5 days or something like that, then or 10 days. So then they can come, I can look it over for them and go, okay, yep, it looks good, or this isn't really not good. I've seen too many cases where people have given away the farm at a mediation because they weren't represented or they trusted their other spouse who maybe didn't disclose everything on the financial affidavit or didn't produce all the documents. And I could
Mm.
tell you horror stories about that. Um, but before they go to mediation, they really need to exchange financial affidavits so they can see what each other has. And there's something called mandatory disclosure, basic bank statements, savings, checking, credit card statements, deeds, things like that. So they know what they're dealing with before they go to the mediation. But to answer your question, the mediator will not then do the filing for them. They have to go to then one of them has to still file the petition for dissolution of marriage. And there's a lot of forms we have. There can be an acceptance of service at one sign, so there's no service. There's an answer and waiver. There can be a declination of counsel, a lot of different forms.
Yeah.
And then you pay the filing fee and it's filed, and then you file the marital settlement agreement or the parenting plan. And then you still have to do the final judgment. And there's a checklist the court wants you to fill out too, depending on which county it is. So
Okay.
there's still a lot to be done even after they have the settlement agreement signed.
Yes. Okay, that's really helpful. So coming back to the financial affidavit part, I have some clients who have attorneys, and the one spouse is not providing all the documentation for the financial affidavit, and the there's been a motion to request in 28 days, that was their state, and still nothing. Like, what are the options that a lawyer would have if they're not getting the documentation? Like, do they end up just having to do court hearings, or what are the steps that you would do if your opposing counsel and their client are not providing what's necessary?
Yeah. Okay. So the first thing I would do is pick up the phone and call the opposing counsel. And if they know what they're doing, I'm going to tell them, hey, you know that the financial affidavit is mandatory. It has to be produced. And if your client doesn't produce it, we're going to file a motion for contempt and seek attorney's fees. And it's going to make your client look bad, and it's going to make you look bad. So why don't we avoid all that and let's work together and get it done? Because there's no upside to you or your client to not produce it.
Yeah.
And 99% of the time they produce it because they know they have to. I have had some occasions over the last 38 and a half years where the attorney on the other side says, we're not going to produce it. I file a motion for contempt. The judge enters an order granting it. And then I actually had one where the attorney or the other side produced it then, but it was blank and signed. And I'm like, okay, this is not in compliance with what the judge said. And we had a second hearing. The judge was very angry at the attorney, and it was not good for them. So it makes no sense not to produce the financial affidavit. It has to be produced unless the parties agree. There is a form now that you can waive it. I don't really like that because I say the financial affidavit is the most important document, the most important financial document in the case.
Yeah.
And there's no statute of limitations on a fraudulent financial affidavit. So if your spouse gives you a financial affidavit and it says, I have these assets and these debts, and they leave assets off,
Uh-huh.
then if you find out a year later, 10 years later, there's no statute of limitations. You can bring it out, and I've done that. So
Mm.
every case is unique,
Yeah.
but I like that because the financial affidavit is sworn to under oath, and
Ah.
it has to be accurate.
Yeah. So even if the marriage settlement agreement says everything in here is final, nothing, alimony won't be changed, but if they realize down the road that something on the financial affidavit was left out, you can bring it back even though the settlement agreement says this is final, because there was not honest information for the decisions.
Yeah, if the judge determines that it was, quote, fraud on the court. So, like I had a case where representing the wife, the husband was a very successful businessman of a multinational corporation, and he said he didn't have any stock options. And then she having a glass of wine with her girlfriends later on, whose husbands worked there, and all these stock options came in, and they were giddy, like how much all their husbands were getting, and her husband was a former husband now was their boss, so she knew he had to have gotten a bigger stock option. So we had
Yes.
to go back in. The judge held that it was fraud, and he had to pay my attorney's fees. He had to pay her half of those stock options.
Wow. And so in that case, those stock options were a marital asset that are split 50-50 or negotiation of some split.
Yeah, if they're a marital asset, then because Florida is an equitable distribution state, equity means fairness,
Yeah.
and it's determined the starting point is a 50-50 split of all marital assets and debts. So just to define that for you, a marital asset or a marital debt is anything that was earned or accumulated in the terms of an asset as of the date of the marriage. So let's say you got married January 1st, 2000. Anything they earned or accumulated after that. There are some exceptions like an inheritance that is kept separate or something like that,
Okay.
or any debts they incurred after January 1st, 2000 are considered marital unless there are always in the law exceptions, unless it was for marital waste or illegal or something like that. So, oh, and it's from the date of marriage to the date of filing the petition. Once that petition is filed, those are the two bookends for
Okay.
what inside of those two is what's marital.
Okay. So if someone is deciding when to file and they knowing that all the assets really end when the filing, they have to be aware of that.
Yeah, and a lot of people ask, is the date of filing the petition for dissolution of marriage an important date? And I always say yes, because it affects a lot of things.
Hmm.
If you're concerned that your spouse is out there running up a lot of debt, well, you want to cut that off. So debt they run up after the date of filing would arguably be all their debt 100%. And if the husband, well, stereotypically, if the husband's going to pay alimony, and under Florida law, we have short term, medium term, and long term alimony cases, meaning less than 10 years, 10 to 20, more than 20. And the husband, let's say they've been married 19 years, he may want to file before the 20th year, because after 20 years, he's going to have a longer amount of alimony under the
Sure.
durational alimony formula.
Yes. Yeah. I think when we got divorced, the long-term marriage was 17 years. I guess it changed over
It's
time.
changed, yeah, it changed with the new statute. So I know this may be beyond the scope, and I'm sorry if I'm talking too much,
No,
but
this is wonderful.
the legislature changed a bunch of stuff. There's no longer permanent periodic alimony. That's been done away with in Florida. Durational alimony changed, like you said, long term used to be more than 17. Now it's more than 20. And now we have a formula for durational alimony, which we never had before. And it's
Mm,
basically the difference in the husband and wife's incomes, their net incomes. So if he makes 10,000 a month net and she makes 2,000 a month net, there's a difference of eight, and then it's 35% of the difference. So
mm.
it makes it a lot easier because it used to be very subjective. I don't know if you had that in
Yes,
your case, but
it
now,
would.
yeah, there's still five types of alimony in Florida. Durational is not the only type. You
Oh,
have temporary, you have bridge the gap, you have rehabilitative, you have lump sum, and you have durational.
okay. Okay, that's interesting. Yeah, maybe on a future call we can define what each of those are.
Yeah, I'd be happy to.
Yeah. What about let's say they file and they are living separately at that time and there's no agreement for like temporary help. Um like in my case there wasn't an agreement and I just kind of like s- sold stuff to make it to mediation like I was living on nothing but my lawyer didn't say anything about temporary, and someone mentioned it to me, and but then it sounded like I would have to go to court for a hearing. And that didn't sound appealing. And I was like, I think I can just make it to mediation. But like, what what do you recommend to your clients in situations like that?
Yeah, so obviously it depends on the specific circumstance of each client. So generally, in Central Florida, all the counties pretty much require that the parties go to mediation before you have a hearing. And
Yeah.
the reason for that is somewhere around 80% of cases are going to settle at mediation. And the judges, so if the judge has, then they have more than this, but let's say they have 1,000 cases, well, 800 of them are going to settle, so they only have to deal with 200. So judges love mediation.
Yes.
That's number one. Um, so yes, unless the parties can agree, then the court's going to have to make the decision. So before you go to court, you have what I call de facto. It's just the facts. Whether it's can the parties put together a temporary time sharing schedule for the children,
Right.
or will the payor spouse, typically the husband, not always, um, will he agree to give her a certain amount of temporary alimony, temporary spousal support? The good thing about the date of filing also is that there's an administrative order that goes into effect. It gets served with the petition for dissolution of marriage, and it says you must maintain the status quo. You cannot drop your spouse from insurance. You can't take her off the bank accounts. You can't drop her credit cards. You have to continue to pay everything that you have historically paid so that it maintains the status quo until you either get to mediation or resolve it, or you get into court on a temporary relief hearing. And that's where, if the mediation does not settle, then you go to court for a temporary relief hearing for anything from temporary alimony, temporary child support, temporary exclusive use and possession of the marital home, temporary time sharing. I mean, it could be a lot of things.
Yeah. Okay. So they're not supposed to take the person not to take their spouse off like the joint bank account, like all of that's supposed to stay in place until mediation.
Yeah. So sometimes um, spouses try to be tricky, and this is what you call divorce planning.
Mhm.
And they find out from their attorney, oh, there's just going to be this administrative order. You can't, once you file, you can't close that, blah, blah, blah. So they go in the day before or the week before. They close all the joint bank accounts. They cancel the wife's credit cards. I mean, I may have just had a case come in today that just hired me that happened. So, and we're determining whether he did that after he got served with the papers or after he was aware of the filing or before. And we think it was after. So we're going to file a motion for contempt.
Okay. So the steps, like when you, for example, this is a perfect example, file a motion for contempt, then his lawyer gets notified from the courthouse.
Well, when you file the motion for contempt, everything's e-filed now, right? Electronically. So opposing counsel's on the electronic filing, so they get the motion. The court gets the motion. The clerk gets the motion. You then have to. Gets a little bit in the weeds. I'm sorry, but you have to do what's known as a meet and confer with opposing counsel to coordinate the hearing date.
Mhm.
Again, you have to wait until after you've been in mediation. You have the hearing, and then you go in and tell the judge what happened. And if the other spouse closed everything after they got filed, after the case was filed, then that spouse is going to be in trouble. The judge is going to order them to put everything back. They're going to probably order them to pay my attorney's fees, and it's going to prejudice the judge against the person who did that. So I would never advise my clients to do that, because the judge is going to make the ultimate decision. You do not want the judge to be predisposed against you.
Right. So if you have a situation like that and the judge now is annoyed, maybe that incentivizes them to finish in mediation with the recognition that now the judge is not too impressed with you, with that person. So maybe if like your client, it gives her leverage in mediation to be like, you don't want to go back in front of the judge.
Yeah, I'm definitely going to file the motion so the other side knows we've got it pending. Like
Mm,
I've got a mediation tomorrow morning. I have a motion for attorney's fees scheduled for a hearing on Tuesday next week, and they know it's pending.
mm.
So I am applying some additional pressure on them to to resolve the case.
Gotcha. So they can, let's say there's a pending motion with a date to meet in court. If they want to avoid that court date, they just then supply or agree to what the motion was, and then it kind of makes the motion go away, or you remove that motion once they've participated in what you were asking.
Yeah, so if you go to mediation and you settle the issues that were pending with the motion, then there's no reason to go to the hearing. You've settled the case. And
Oh,
typically in mediation, when you enter into a settlement agreement, it's going to say that this settles all of the issues. Or sometimes you do have a partial settlement and you reserve on the issues that were not agreed upon. You can reserve on like alimony. You can reserve on attorney's fees. I
okay.
always say those are the two A's people hate to pay: alimony
Mhm.
and attorney's fees.
Yes. Okay, what about a situation where like one of the spouses owns a business and trying to like value the business is a whole huge process. They could do all of mediation for everything else and kind of table that if that's taking longer.
Yeah, that is true. If you, depending on the complexity and the size of the business and whether it's personal goodwill or enterprise goodwill, whatever, you may need to have a financial expert do a business valuation.
Mm,
There are abbreviated business valuations that are less expensive, and then there are full-blown ones that are very expensive. So we try to do the abbreviated ones, and that's fairly common.
mm, okay. Let me see. So two things. You said, let's say there's a hearing or a motion with a hearing date, and the goal is to then agree in mediation. But what if getting a mediation date, like it seems like mediation dates are always like 2 months out from some of these situations. What are the options to try and like get them resolved before the it has to have the hearing date if mediation is kind of still further out.
Yeah, so I think it's really important to try to communicate with opposing counsel and work together.
Mm,
Um, Honestly, I think most attorneys are willing to do that. You
yeah,
do have your exceptions. There are some attorneys that are very difficult, and
yeah,
you know who they are if you've done it a lot and
yeah.
you're experienced enough to know you're going to beat your head against a brick wall.
Mm,
So if they're trying to push the mediation way out for whatever game playing or whatever, I don't know, but um, I will, if I have to, I'll file a motion with the court to compel mediation
oh,
because they're delaying it. So
okay.
yeah, so some attorneys will say, "Oh, I'm not available for mediation for 3 or 4 months." I'm like,
Mm,
"Yeah, that's not going to work."
yeah.
Um, but most lawyers will get a mediation within a month or two. It's unfortunate that it can sometimes take a while to get a mediation.
Yeah. So what if like the situation is you need that temporary agreement for support or something, but mediation's a month out. Can that be done just between the lawyers if
Yeah, it can definitely. Again, if you have two lawyers that are halfway decent and willing to work together. But reality is none of the credit cards should have been canceled. Access to the joint bank accounts should still be there.
Mhm.
Um, access, checking, savings, money market, whatever should all still be there. And the
Yeah,
administrative order says that each party is allowed to take monies from those for ordinary living expenses, not extraordinary. You can't go out and buy a new car or a boat, but it
right.
also allows you to take it out to pay your attorney's fees too.
Mm, okay, interesting. Um, what like for a judge, like what we were saying, what you were just saying, like some attorneys are just difficult or they want to drag it out, and because you're part of the community, but like are judges, I guess they also are very in touch with, are they aware, and how do they handle lawyers who are dragging it out or make it difficult to get to resolution?
You know, I think judges are smart, and I think judges talk,
Mhm.
and they know who are I think mostly know who are the attorneys that are willing to work on things and get them done, and who are the attorneys who are not.
Mm,
Judges appreciate attorneys that resolve things and don't clog their court with
right,
unnecessary motions. So if 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 you go in on a motion for contempt and it's clear the other side closed the bank accounts after they got served, it's not going to go well, honestly, for that person if the judge decides that they have violated the administrative order. So
right.
there's really no upside to that.
Yeah,
And again, most attorneys realize that and they want to get things resolved. And um, I really like to try to work things out with other attorneys. I have a lot of cases where I actually recommend to the client that we do like an informal settlement conference if I know it's a good attorney on the other side, and just the four of us can meet, or we can exchange parenting plans or marital settlement agreements and get it done even without a mediation. We can get it done before a mediation.
really.
Yeah, I have a
Okay,
couple of those now going on.
that's wonderful because
Yeah, that saves everybody a lot of money because,
I know.
mediations are expensive. You're paying your attorney, the other attorney's getting paid, the mediator's getting paid. You got to pay, you know, for all these expenses. And it's just, sometimes it has to go to mediation. Sometimes it has to go to court, unfortunately.
Yeah. The documentation that needs to be supplied, like the bank statements, what if the credit card statement, sometimes it seems like that is something that in contentious cases they're just not providing, and even when a motion has been put in place, I guess until they go to court under contempt, like there isn't much else that can be done if they're just not providing that.
Yeah. So if they don't provide it, you have to file a motion, go to court. If the judge orders them to produce it and they don't, now, if you go back in again and they didn't produce what the judge ordered them to, the judge has the ability to put them in jail.
Wow. Okay.
And judges like to say that there's no greater motivation than somebody spending the night down at 33rd Street Stockade, and not a fun time. So most
Yeah.
people, I've been in hearings before when, yeah, that's been ordered and everything gets provided lickety split at that point, typically.
Yeah. Oh, wow. I didn't realize that was even an option, but
Yeah,
that's
judges have contempt powers.
okay. That's really good to know. Trying to think if there's anything else that I had thought of um that I didn't ask. Oh, what about like if it's a pretty contentious case and then the lawyer says they want to do a deposition? Is that more of like an intimidation tactic, like before mediation happens?
Well, it depends on the complexity of the case and what the issues are.
Mm,
Um, if I it depends. I typically, it, sometimes more rarely I'll do a deposition before mediation, but I'll certainly do a deposition before trial or before a very complex evidentiary hearing because you want to know what the answers are going to be when you ask the questions before. So um, I wouldn't do it for intimidation. I don't think most lawyers would. You do it to tie down what the other side's going to say and to learn facts about the case and about assets and what happened to things and issues maybe regarding the children. So depositions are expensive, but they can be very valuable.
okay. So if things are going towards court, that's kind of when they become
Yeah,
practical.
typically, yes.
All
Yeah,
right.
and a lot of these things that I'm saying are obviously fact dependent on the specific case, and none of what I said is supposed to be considered legal advice to any specific client or
Sure.
potential client. It's, generally, these are what happen in these cases legally, and from my experience, generally, what I see happen.
Yeah, no, of course. One other last question. For time frame from divorce, since you do both litigation and collaborative, do you find that collaborative moves faster than a typical litigation, or is it really just case dependent?
Well, I think it is case dependent. However, I can say that I think that typically collaborative moves more quickly. I've had collaborative cases settle after the second meeting. So we met, got everything together, agreed on everything. We met for the second meeting, hammered it out, and signed the agreement. So I think it can get done within maybe 60 days because everybody's voluntarily getting everything to the financial neutral and the mental health neutral, and they're putting together the equitable distribution worksheet, the alimony analysis, child support guidelines, the marital settlement agreement, and the mental health neutral is putting together the parenting plan, come together and get it done. I think typically collaborative cases, 3 to 5 meetings. 2 is the shortest I've seen. Whereas litigation, again, depends on is it going to settle at mediation or is it going to be contested? If it fails at mediation, becomes contested, and then you're moving toward trial and then going to trial, it's going to be longer. It's going to
Yeah,
be way more expensive,
yes.
typically.
Yeah.
Yeah.
Okay, this was like so helpful and informative. I really, really appreciate you taking the time. And it's nice always to have you join us.
Yeah,
And
I'm glad it was helpful. Sometimes I wonder if I give too much information because there's just too much going on, but hopefully this has been helpful.
yeah, I think more information than less is always helpful. For what I find is clients are just a little bit in the dark. A lot of times I think lawyers, they know all of it, so they just assume it's, self-explanatory, or they just don't have time to explain some of these basic things to their clients. And so the clients they just get little tidbits of what's going on, and just sometimes they just want more information. So I think at least something like this gives them a better big picture of what to expect.
Yeah, I think information is power, and I think letting the client know more rather than less is helpful, and letting them know what the next steps are or what to anticipate helps lower their stress level, helps them kind of visualize, picture what could happen. And nobody knows exactly everything that's going to happen, but you can give them essentially the parameters of what's going to happen in a case typically. And I find clients to be very appreciative of that.
Yeah. Oh, absolutely. I think That's a sign that you're a good lawyer because you actually are putting yourself in your client's shoes and recognizing how helpful that is.
Yeah, I just realized how horrific it is for so many people who go through divorce because nobody gets married typically planning on divorce. They hope and plan and pray for a lifetime of marriage with their partner, and all their dreams and hopes come crashing down sometimes. So it's hard. I think it's important. Like you're doing a great job for clients because you can help walk them through the process and the emotional issues and so forth. And I think it's a good thing for clients to have a therapist too when they're going through a divorce to help them, manage a lot of the anxiety, stress, emotions, and things like that,
For
and helps us,
sure.
you know. I know my letterhead says attorneys and counselors at law. Um, we end up doing a fair amount of counseling. Not that we're not, licensed mental health therapists,
Of
but
course.
when you've done family law long enough, you realize there's a lot of psychology and emotion that go on in a family law case.
Absolutely. Yeah. And that's the thing. Like, I always encourage my clients to have a therapist and use their lawyer for lawyering and have a divorce coach for the emotional because my billing rate's a lot less than any lawyers. But yeah, I think it's inevitable that the lawyers are going to have to, like, sometimes talk their clients down or calm them down. And, I think having an empathetic lawyer is probably very beneficial. So,
Yeah, I hope so. I think so.
yeah. All right. Well, thank you so much. And until next time, have a wonderful holiday season. And I will see you on the backside.
Okay. Well, I enjoyed being on your show. Thank you so much, Lee. Appreciate it.
Thank you.
I'll see you soon.
Okay.
All right. Bye.